stage. We're going to discuss international transfer now, and I would also like to introduce on stage Peter Shah, who is the chairman of the European Academy for Freedom and Information. Peter has a very long and super impressive CV when it comes to data privacy, amongst other things, Federal Commissioner for Data Protection previously. Also, if I could introduce Michael Hopp on stage, who is a partner at the law firm Plessner and has been working with privacy for 20 years. And from our introduction calls, seems to have been dealing with a lot of super interesting and difficult client matters over the years. So that will be interesting to hear in relation to international transfers. Last but not least, I would like Anna Pouliot to come back on stage. Since Anna has already been on stage once, I'm not going to go into a long presentation again. So, international transfers. Something that we discussed last year as well. Then it was mostly about Brexit, since that is a done deal. Now we don't have to mention that at all. No, I'm kidding. It's not. But we're not going to focus on that this year. Or maybe did you want to focus on it? Also, we can. No. I think when we had the pre-call, we wanted to make sure that this panel gave some practical experience as far as we could in regards to international transfers. And I think first very open question is, how do you see that the current transfer mechanisms are used in practice? And maybe start with Anna, the lady on the stage.
Yeah. Currently, there is a little bit of uncertainty. I think in the past years, we have experienced that with the collapse of the safe harbor. I was part of an organization that had thousands of relationships depending on safe harbor, and we were rushing against the clock to do something in the grace period given by regulators. There's Brexit now, and what happens with your transfers towards the UK, but also data that you send there and perhaps leaves to other destinations from there. What about relationships that are not covered with the standard contractual clauses that are available to us right now? Because we only have two types, as you know, and there are other relationships that need to be covered. A privacy shield that is, again, into question mark and to be evaluated. Standard clauses, again, being the subject of a lot of debate and challenging. Binding corporate rules. I've done 5 sets in my career, to some extent, for controllers and for processors. That's what I mean by 5 altogether. Again, a very difficult, very expensive mechanism that is reserved for only few, and then certifications that currently we don't know more or less where they are. And that's only to cover your data transfers from the European Union to other jurisdictions. You have challenges in an international organization, of course, with another country's laws that have data localization requirements and so on. So currently, nothing is ideal. Adequacy as well, another route, Apex. I mean, it's the landscape is not clear. But I think we have to be able to navigate through the uncertainty. I think that we've seen with the safe harbor that there was a lot of understanding from regulators. There's as much as you can do, actually, if there is uncertainty and if there is a collapse of a certain mechanism. So an organization should take that for a fact right now. There's a lot of war on data sovereignty right now between member states. You see India coming with a new law. There are some data localization aspects. We'll see that more and more. We see the US moving in certain directions. So accept that as a fact. No panic, because you just have to strategize what is the best way according to your organization. If you are a big organization, perhaps the binding corporate rules is a good mechanism. You invest a lot, but you get your organization up to a standard that then there is some synergies that you could use for transfers then in other jurisdictions. BCRs are not just Europe. There are some, and I'll come to that later. There are some other utilities. But where I see the problem, and I'll close with that, is that we see it very often. Management will think, okay, I'm doing binding corporate rules, I'm fine. Or I have those standard contractual clauses, they're signed, they're put into the drawer, and that's fine. Where I think you show the accountability is by how do you enact the commitments that you made, either in the binding corporate rules or, you know, in the in the Privacy Shield, if you are a US organization or if you are interacting with US organizations. How do you enact also the engagements you made in the standard contractual clauses, which are pretty standard, but then again, you may have some variations to take into consideration, and you have to flag who are your counterparts that are bound, onward transfers as well, onward transfer agreements. So how well do you follow them? Do you have really tools and rules for your organization? Do you check on them? Because if they're just paper thrown somewhere, which is what I'm afraid a lot of organizations are doing, then they mean nothing. It's not, I have a mechanism and I throw it in the eyes of the regulators or whoever asks for them, but it's how do I make it in practice, and I need control.
And I think, you know, Michael, you obviously give advice in this area quite often, both based on what Anna said, but also from a lot of your experience. What is the concrete practical thing, apart from not panicking? I like that one. I'm taking that one with me home. But you know, what should companies do that are dependent on transferring data? Or
Well, I agree that no one should panic. I don't think people are panicking. Maybe we see small signs that this is going to be the third wave under the GDPR. The first wave was understanding the rules. The second wave was working with achieving accountability. And now we have the third wave of understanding the international aspects of working with privacy. And of course, we all know that the rules are not that different. They have been there since 1995, implemented nationally. But as was just said, I think to a very large degree this has been a tick box exercise. It's been a paper tiger exercise. I think people have struggled with getting around this because they have had other more obvious challenges at home, so to speak, because these rules are really not enforced in practice. So the focus have been on sorting out the issues at home. But we're living in an increasingly international world where things move really fast. And I think this will be the next area of interest.
Even though absolutely no panic, I think when the safe harbor collapse took place, the amount of hours that was put into, okay, what do we do now, and how do we actually find another solution amongst companies, and how do we find all these contracts, that did create a little bit of panic. And now we have the Schrems 2 case being dealt with currently. Is there anything, I understand it's an ongoing case, Alton, so you probably can't say a lot, but is there anything that you can share in regards to that?
There's not a great deal, I suppose, beyond the fact that we had the hearing in July where argumentation was heard for pros and cons of what we've done at the DVC in bringing the case, and we'll see where it goes to. I think a decision will come out in 2020. But a bit of background, and I'm not the lawyer, I'm a technician, by the way. They're turning me into a lawyer. The case was brought because Article 47, I think in our opinion, wasn't clear on what the impact of a suspension of SCCs would be, whether it was on a case-by-case basis, whether it would mean that SCCs in general were gone, and then what happens to other adequacy decisions. So in some ways, it's a question around adequacy decisions and what their meaning is. So we'll see where they go. Interestingly enough, Facebook appealed that in the Irish courts. It went to the highest Supreme Court in Ireland. It was rejected there, and the judge made the comment that the DPC was correct in taking it to the ECJ. So I think we're quite confident that we've done the right thing and that's the right route to go to get some clarity on this. Of course, the impact and the fallout may have, there will be a large impact, a large fallout if it goes one way. But as has been said, the panic shouldn't really be there. I think when Safe Harbour collapsed, as we've said, we certainly weren't out to start a witch hunt and get organisations to comply. But we'll see where it goes.
Well, if we look back to the Schrems 1 case and the decision of the European Court of Justice, the substance of this decision was that in the safe harbor, it was not taken into account, or were not taken into account all relevant aspects, as, for example, and especially the law enforcement and Secret Service activities and the legal basis for those activities in the US. That was the substance of the, so as I understood that. And this argument also applies to other instruments. This is clear, and therefore there was a risk. But since then, something has changed. There's not only the Privacy Shield as the follow-up of the Safe Harbor with very similar instruments, but with a more robust system of guarantees of the US, and those new guarantees also apply for the other instruments, like the SCCs, the BCRs, and the codes of conduct. So I would say there is a risk for all those instruments, but there's no reason to panic and to go again to the SCCs. So I would say the risk also applies to all of the instruments. And if companies live data protection, and they install a robust system of data protection, and they do the best they can.
I think so. And just on that point, and the point you were making earlier around enforcement of these things, there is talk about instruments like BCRs, those paper-based ones, of being followed up with inspections at some point. But also, when it comes to it, say in a breach circumstance, where there's a controller in Europe who has a processor in the United States or elsewhere, who in fact does most of the work, in fact, if not all of it, then we have and we will look at what governance has occurred in that case, where the European controller, how have they exerted their purpose and intent on what is happening? And that gets very quickly into the heart of the relationship between the controller and the processor, and how they've carried out what they've said on paper. So that is going to happen, it does happen.
And there were some cases before the FTC where the FTC was acting against companies with misleading statements to be compliant with the safe harbor, with the privacy shield. So they are doing more than they did before.
Yeah, Michael.
I just think that this whole thing about the Schrems 1 and Schrems 2 cases, that we're all looking to the US as being the bad guys in these international cases. And the thing is, I mean, depending on the ratio of the Court of Justice of the EU when we get Schrems 2 decision, what about other countries outside the EU? I think we can all find more obvious examples of challenges.
Yep. I
mean, if you can challenge the Privacy Shield in Schrems 1, and now you have Schrems 2 with the model clauses, what will happen to other countries? I think that's at least as interesting, if not more interesting question, which is not really being discussed.
No,
Brexit.
Definitely.
and I may add, what about the practices of the European authorities?
Yeah.
So this is not covered by the competence of the European Union. No. This is the problem. But those practices are very similar to the practices of the US law enforcement and Secret Service authorities.
We had a very interesting chat during the break, Michael, in regards to how to actually continuously secure privacy when data is transferred out, which also links back to what Anna was saying. You need to have proper mechanisms on following up and not only having this as a paper exercise, but you had some interesting experience in this field.
Or the lack of experience.
Sorry.
Well, my point was just that, I mean, we've had model clauses for 20 years almost. For example, the controller-to-controller clauses say that the importer, the recipient, the receiving controller, cannot use the data for other purposes than the ones set out in the model clauses. And there's no test of compatibility of purposes. It's just same purposes or nothing else. I have not, in my years as a lawyer, had one single question from a client about how to handle that prohibition on the use of the data for another purpose by the data importer. Not one single question. I can ask the lawyers in the room, have you ever advised about the purpose limitation in the model clauses under the controller-to-controller model clauses? I see no hands.
One hand over there. Okay.
One hand over there.
Yeah, you have to have a discussion with Tobias afterwards to see what that was about.
But my point is just that, to be honest, I think a lot of data importers, either controllers or processors, have never actually read the model clauses.
Yes.
And even if they had, they have no genuine intention of complying with the obligations set out in the model clauses. To be honest, and I'm not pointing fingers because we need international transfers. I mean, we need data to move around to make things work, both as public authorities and as private companies. But I think we need to revisit this whole area and start working with the requirements in a in a way more similar to the accountability that we know for the ordinary rules.
And maybe, Anna, I'm not sure in your role as an expert for the GDPR multi-stakeholder group, or maybe in your previous position as the DPO at Chanel, but you said that, you know, we need to make sure that it's not only a paper exercise, we need to follow up. Do you, in both roles, do you have any advice, and do you think that there is something that the regulators should do, or is it more so on the businesses in this regard?
I think it is a change of culture, a change of corporate culture. We are now in a framework of accountability, so we can no longer speak about the regulators and the regulator. I mean, the regulators, they have so much on their desk, and I would be more in favor that they focus on the more important things there. Standing on the other leg that Albin was talking about, which is the internal DPO and the accountability of a company. Peter mentioned very correctly what matters, you mentioned that as well, is having the robust system. You call it standard contractual clauses, you call it binding corporate rules, you call it whatever. At the end of the day, there are certain rules. Yeah. If the rules are like a paper that is signed and nobody from your IT division, information security, has read it, then it doesn't help. It also does not help if they count on the privacy team or the DPO office to comply. It's not up to them to comply. It's the whole organization that has to come to a new culture, which is privacy by default, privacy by design, and the transfers securing, in fact, that your providers, you're checking where they transfer the data, if there are like further transfers to sub-processors, for example, and so on in other countries. So there has to be a strategy, there has to be a well-thought-of process that can lie with the privacy office, perhaps, but then you need a communication with the business, and these people have to be trained, they have to be aware, they have to be sensitive, and you need to have buy-in from your management that imposes the message that this is important, otherwise it will never, ever work. No. And so I'm speaking more of an accountability standard that needs to be there wherever in your organization you transfer the data internally, but also a due diligence on whoever you transfer it externally.
Yeah, may I add one point on codes of conduct, Article 40 and Article 41, because this is really a new instrument for providing guarantees for an adequate level of data protection. And the real innovation in this field is that Article 40 is combined with Article 41. And Article 41 says such a code of conduct can only be approved by a DPA if there is a robust oversight mechanism. And there should be a monitoring body that has the oversight on the compliance of those who joined these codes of conduct. Therefore, I would say it is not only the question of paperwork, it's also that there have to be installed mechanisms of oversight. The DPOs are one element, the data protection assessments are one instrument, and the oversight board according to Article 41.
Absolutely.
I completely agree with you, Anna, in regards to maybe we shouldn't put more tasks on the DPAs.
Yeah.
They have so much to do already. At the same time, there was a previous discussion in regards to the data controller, data processor relationship, where one of the things that I can't remember if it was on stage or in the preparatory calls, where one of the issues that we're seeing is that even the audit obligation is now being something that is really negotiating in the contractual phase. So you can't get it in at whatever kind of flexibility that is needed. So is there, in regards to these audits, I guess that would be one of the things that then should be put more effort into. Is there anything that we can get guidance on that, or how do we develop this mechanism, not only in the code of conduct, but overall to work better? Yeah, it's an open question. I don't know if it's...
Well, it's the controller who's the responsible party. So in the situation where we would investigate a case that comes before us with an international transfer and a transfer agreement, the controller has to be able to demonstrate what they've done and be accountable for that. So if we find that there's a transfer agreement that's been gathering dust on a shelf somewhere, and there's nothing within that organization's record keeping, within their monitoring, within their internal audit, with their governance, inspections, all this, if none of that has happened, if there's no record keeping being done, then that's an immediate signal to us that it's a paper tiger. So those kinds of things can't happen, and we've been through this already with a certain organization's breach. Accountability is a huge element. You've got to do it. You've got to be keeping those records. You've got to be able to prove to us that your processing is proportionate and necessary, and so on. And codes of conduct are going to help that, absolutely. They're a huge tool that we can use. And we expect organizations and stakeholders in the public to come to us and to come to the EDPB with codes of conduct and certification on these matters and others. And they're going to happen very soon. On the international transfers, certification is being talked about now at the EDPB level as a guarantee mechanism. Codes of conduct are underway already. There are some being reviewed currently in certain industries, and I think certification has a good opportunity there as well.
Peter, we spoke a little bit beforehand, and you said that there are some things happening in the Privacy Shield reviews that might be interesting to share.
Yes. Well, there were some innovations in the Privacy Shield compared to the previous Safe Harbor agreement. One of them was the Judicial Redress Act, the installation of an ombudsperson associated with the Department of Commerce. And a third, there was the PCLOB, the Privacy and Civil Liberties Oversight Board. And the very recent development is that now this Privacy and Civil Liberties Board, the PCLOB, now is complete again. The first time since 2016, not 2016. Then the Senate approved all members of this board, and they are very high-profile persons. And I think this is very important because they have to carry out the oversight on secret services and law enforcement in the field of fight against terrorism. And this was one of the main arguments against the Safe Harbor, because there was no adequate oversight even on this field. And therefore, my impression is, but we will see what the judges will decide. But my impression is that now the situation is better than before the decision on the safe harbor, and the risk is lower that it will be annulled again.
That's the kind of news that we want to hear. Sorry.
Yeah, and I agree. We'll wait and see what the court has to say, but I mean, all those essential guarantees are up for grabs, I think, in the decision. And things have changed. But, for instance, last year I spoke at a conference in Boston. I was asked a question by a Harvard professor about when will Privacy Shield be reviewed or renegotiated. And I said, it's not, it's going to be reviewed, and it is every year. It turns out she happened to be one of the 20 members on the adjudication team for Privacy Shield. So there seemed to be some misunderstanding even there about what was going on. So we'll see where it goes.
Oh, okay. So some positive news and then some little bit scary. Again, I would like to open up and see if there are any questions from the audience. We have a question there. Let's see, there's a green mic on the table right there. If we can try to throw that over to Alexander. I'm so happy it's not on the stage anymore. Thank you. Alexander.
Hi. So when talking about third country transfers, one of the big issues that I come across are derogations. So I have 2 complaints currently under investigation, one in the Netherlands, one in Germany, about Mobike, a popular bike sharing service out of China, sending all that data back to China, all this location data, all the information about where we're going, et cetera, on the basis of consent. Now, the EDPB have issued guidance on consent, stating that it must be for a specific transfer or set of transfers, but it's too ambiguous. Where do we go? What is a set of transfers? The whole point of a derogation is it's supposed to be an exceptional situation as opposed to normal operating procedures. But we're seeing with regards to third country transfers, particularly to China, India, etc., a situation where consent is being used as the legal basis, despite the fact that it's a derogation, despite the fact that there are so many issues around consent anyway, and despite the fact that the requirement is that consent must be explicit. So what can we do to clarify this issue and prevent this problem from going even further than it is currently?
So who feels that they can answer this super easy question? Thank you, Alexander.
Well, we have a general question relating the consent. And the one question is whether a consent will be valid if the company urges the customer to give the consent as a prerequisite for use the service. So without regard to the international data transfer, I would have doubts that the collection of the data and the processing of the data should be based on the consent in the field if you want to use a bicycle or so in Europe. Secondly, of course, you have to take into account whether the consent is very clear and the customer might understand in which processing he is consenting in. And therefore, I have doubts that that would be the right way. And if, additionally, the consent covers adequacy, I would say this is not the right legal basis and the legal ground for transferring the data to China or so.
And
Very widespread.
Yeah, I know that.
Maybe, I think you alluded to that before, we are worried too much about the US because of the whole situation with Schrems, and not only, with Snowden basically, but we're not looking at the other jurisdictions. I survived a Russian investigation, for example, and that's an entirely different thing. I think the concern was because tech giants are basically in the US and because we have a lot going on there, but that's going to change. And perhaps worthwhile saying that the consumer may drive this a lot by choosing the right solution. It's very easy to get consent by giving them a discount or whatever. I can tell you I was at the airport the other day and they said, well, if you give us your email, you get 5% discount. Everybody gives their email, sign whatever to get the discount on product in the duty-free. So consent is very easy. There is a whole effort from the European Commission on adequacy, that Peter mentioned, because adequacy is important. We shouldn't underestimate this effort that is done by DG Justice, by the International Department. They are into contact with Korea, with Japan, with India, with Israel.
With Japan, we have a new agreement.
Exactly, exactly.
Very good.
And there is an ongoing discussion, and there's very good understanding, and they're trying to put India onto that. We had extensive discussions there. And so there's this, in Brazil they're trying to bring, developed countries where there's a lot of tech industry up to a certain standard, so that we have, convergence of systems, and that's what's going to help. It has to be at that level, because an individual cannot do that. But I think currently, the way things are, that's where the enforcement has to step in, and that's what I mean with significant matters for the enforcement agencies and the DPAs, actually, because if they see the data goes to China and then whatever, then they have the way to fine, block that company, and so on. And I think that's where they should interfere.
That was a great wrap-up. I think just one more thing. There was some really practical advice, and I really want to thank the panel for that. Remember, do not use the transfer mechanism as a paper tiger. Remember your accountability. Have proper mechanisms of actually following up on what you're doing when you're transferring your data. And with that, I will let you go for